Hi, I'm Rajithan Navaratna. My student number is 3248, and today we are going to do a presentation regarding about business law. And this is our assignment 2, group Ali 15, and these are my group members. And we are going to talk about the case ASIC Post Padbury Mining Limited. The company called Padbury Limited is a mining company with two directors, namely Gary Stokes and Terence Quinn. In April 2014, they announced a project called OKG, which is 6 billion investment in Western Australia. In the 4 hours between the announcement, Padbury share price hit up to 5.2 cents, which was 2 cents before the announcement, and more than 200 billion shares being traded. They depicted that the funding by Padbury took place in Alliance Super Holdings Private Limited and Superkit Private Limited. This was the main reason which made ASIC query to know the facts about such a huge investment. Later, ASIC and Australian Stock Exchange made an inquiry on this case, and they came to know in the end of April 2014 that the funding agreement was terminated. So my colleague will continue that.
Hi, my name is Jaspreet Singh Chima. My student ID is KEM3024. Now I will just continue about the duties breached. In this one, there was the 2 directors which were caught by the court that they didn't disclose the funding matters to the ASIC and the ASX. There was the funding issue was the 6 billion, so constructed deep water port, so they just didn't manage to have the condition precedence of the company. And another one situation was the Padbury didn't notify the ASX, Australian Stock Exchange Limited, that they are just revealing this information and didn't take initiatives. Thus, they didn't also meet the requirements as they acquired the 1.3 billions, but also does not reveal the identity to the fund providers. As per the 1317E section, the Corporation Act, they were breached the duties which were unable to compel the ASICs and ASX. Now my next colleague will be explaining the next one.
Hi, my name is Muhammad Shoaib Amanat and my student ID is VSS32105, and I am going to explain the other 2 breaches that was done by the directors. First, both the directors provided misleading statement. In April 2014, Padbury Limited announced that they have secured funding amounting of 6 billion so as to construct deep water port and associated rail network, which was misleading and illusionary statement. Thus, as per section 1041H of Corporation Act, this announcement deceived the information about the availability of funding. And the second one was that they provided, by giving permission to announce such information, both directors have breached the duties as per section 1014H of the Corporation Act. Nevertheless, the duration between the release of the announcement about the OKG funding and the information regarding funding were not notified to the Australian Stock Exchange, and both the directors were duly involved in this breach. So they, according to the section 1014H of the Corporation Act, they breached their duty of announcing the information. And so this is all from my side, and now my colleague will continue the presentation. Thank you.
Hi, I'm Sevandi Chandima. My student number is TGO3003. I'll be discuss the decision made by the court in relation to the case. There are 3 entities eligible for the punishment. The first decision has been made by the court is penalty for both directors. According to the section 1317G of the Corporation Act, the directors Mr. Stokes and Queens are liable to pay $25,000 as penalty to the Commonwealth of Australia. In addition to this, both directors has prohibited to manage an organization for a duration of 3 years. According to the section 206C of the Corporation Act. Finally, board directors are liable to pay $200,000 to ASIC as the cost of proceeding the case. However, the Judge Honor Sophie's mentioned board directors will only face 3 years disqualifications period as they have been well cooperated with ASIC. Furthermore, ASIC stated that directors have been breached the duties and conducted unlawful activities, so it was necessary to have disqualification period and penalty. Additionally, Mr. John Price, the Commissioner of ASIC, has mentioned that such type of misleading announcement by the company directors can affect the Australian market. Thus, this decision is an example to the companies to understanding the significance of not disclosing information to ASIC and ASX. Thus, this decision held correct according to judgment in 2012 regarding James Hardy's case. My colleague will be continue.
Hi, this is Watik Ali Khan and my ID is PFEC 3240. Today I am going to present impact on Australian companies. Every case has some impact on the Australian companies. There is something pivotal to learn from the cases, as the director breached the duties under section 180 of the Corporation Act. It came in the eyes of ASIC and they conducted proceedings. This case should set an example for other Australian companies that they shouldn't intend to breach the duties of the Corporation Act. The punishment these directors received of 3 years disqualification from managing the corporation, as well as penalty of $25,000 will make other Australian companies set back before commencing any such mistakes. Even these directors have to bear the expenses incurred by ASIC, which is around $200,000 during the proceedings. This will not only spoil the goodwill of the company but also make other films aware of the consequences about such awful acts. Despite this, as both directors were cooperative and understanding, ASIC was satisfied with that. As a result, the judge didn't disqualify them for more years and didn't charge them more civil penalty. This reveals that being patient and nice with the department will aid the lessening the punishment, which is a good lesson to be learned from this case. Thank you so much. And this is the reference that we use, and this is our peers evaluation copy. Thank you so much.